Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Kyle Ubel, a Minnesota construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Kyle Ubel.
Good afternoon, everyone. As Jesse mentioned, my name is Kyle Ubel. I practice here in Minneapolis, Minnesota at the law firm of Frederickson and Byron, and I'm here today to talk about getting paid faster with liens, bonds, and contracts. And I need to figure out how to advance my slide. There we go. So let's start with liens. So liens are a statutory right in the state of Minnesota, which means it's not a right that's created by contract or by the court system. It's created by a statute. And what everyone needs to be aware of when you're dealing with liens is that the statute is strictly construed on procedure. What that means is you need to follow the rules precisely that are set forth in the statute on the procedure of preserving and enforcing your lien rights, or you will lose the lien rights. So there's a lot of traps for the unwary here. Who can have a lien right in Minnesota? Anyone performing engineering or land surveying services, as well as anyone who is contributing to the improvement of real estate by performing labor or furnishing skill, material, or machinery to a project. Important to note for construction industry members is that if you are required, if you're doing the kind of work that requires you to have a license, you must hold the required license in order to have enforceable lien rights. The next important distinction for our discussion today is that liens can be asserted on private real estate deals, but they cannot be asserted against public projects. So for example, if you're working at the Minnesota State Capitol and you're doing a job at the Minnesota State Capitol, you will not have the ability to assert a lien on the project. You may say, well, then what happens? And the answer is bonds, which you may recall from the title we're going to be talking about after we talk about liens. There's also a common misconception in Minnesota and in other states that have this, that about homesteads. So in the foreclosure process, where a bank, for example, might be foreclosing on a home, there's all these exemptions that you can't foreclose on someone's homestead. Those rules are different on mechanics liens. If you do work and you preserve your lien rights on a residential project that's someone's homestead, you do have the ability to put a lien on someone's home. All right, let's start talking about some of those procedural requirements that we were talking about, where we said that you have to follow the rules to a T. And we're not going to talk about all of the details today, but I do want to give you a high-level sense of what's required, the timing of the requirements, and then point you to the resources you need to figure out what the exact minutia, the exact details of the rules are. So the first requirement, if you're a contractor, a general contractor, is that you have to give pre-lien notice. This can be given in one of two ways. First, if you have a written agreement with the project owner, the pre-lien notice must be contained in your written contract. So if you're a general contractor listening to this webinar, you should make sure that your form written contract that you use has pre-lien notice language in it. And if it doesn't, get thee to a lawyer. If you are a general contractor who doesn't use written contracts, or maybe it's a side job and you don't use a written contract and it's an oral agreement, that's fine. But then you need to give separate pre-lien notice within 10 days after the work is agreed upon, not after it begins, within 10 days of when you agree upon the work. If you're a subcontractor or a material supplier, you also need to give pre-lien notice, and this is a little bit different. You give pre-lien notice via personal delivery or certified mail within 45 days after your first contribution to the improvement. This, of course, is the case because if you're a subcontractor, you don't have a written agreement with the property owner. You have a written agreement with the general contractor, but you as the subcontractor or the material supplier still are required under the statute to give pre-lien notice to the project owner. And again, you do that by personal delivery of the pre-lien notice or by certified mail within 45 days of your first work at the project. There are strict formatting requirements for these pre-lien notices, what they have to look like, what font, what size font, what language. All of that is in the pre-lien notice statute. If you Google Minnesota pre-lien notice requirements, you will readily find them on Google. Next, now you've done your work. I should add one more thing before we move on from pre-lien notice. To be absolutely clear, if you do not give pre-lien notice in the required format within the required timing, you will not have a lien to assert. It'll be gone. Now you do your work. You give your pre-lien notice, you do your work, you don't get paid, and you want to enforce your lien. Now what do? This part of it is the same no matter who you are, whether you're a general contractor or a subcontractor or a material supplier. You are going to now use a document called the Mechanics Lien Statement. This document is due within 120 days after your last contribution to the improvement, 120 days. There's something in Minnesota called the screen door doctrine. So what was happening is some contractors or subcontractors thought, shoot, I really need a lien, but it's 121 days, so I've lost my lien rights. I think I have to go back and tweak that screen door a little bit. I think it's a little squeaky. So I'm going to go back to the project site and just do a little bit of work on that screen door. And what happened is the courts in Minnesota, when they were looking at the statute and looking at that fact pattern, they said, you still lose your lien rights because we're gonna add to the add to the statute as judges what we're gonna call the screen door doctrine. Meaning, if you're gonna go back and do a little bit of tweaking here or there to try to resurrect your lien rights after they've already expired, you're still out of luck. So it's very important that when you're done actually doing your work, you count 120 days and make sure you're paid by then. And if you're not, get thee to a lawyer because you're going to need help getting a mechanics lien statement filed, and it will not work to go to your lawyer on the 120th day. That will not get done. You have to go to your lawyer with at least 2 or 3 days time to prepare the statement with you and get it filed and served. So what do we do with it? We file it with the county recorder in the county where the real estate is located, and then we serve it on the owner via personal delivery or certified mail. Once again, the procedural requirements are strictly construed or your lien rights are lost. And another really important thing to work through with your lawyer when you're preparing the mechanics lien statement is you cannot overstate the amount you're owed in the mechanics lien statement. 2 bad things will happen if you do that. Number 1, your lien will be invalid. So even if you had a valid lien for $100, but you try to assert a lien for $110, if the project owner proves that you weren't owed $110, your lien is now invalid and they have the ability to seek attorney's fees against you. You don't want either of those things. So make sure you have a very clear accounting and do not round up. Finally, on liens, you've recorded and served your mechanics lien statement with your lawyer, and now you're going to enforce it by filing a lawsuit, which is essentially like a foreclosure action. You're now taking your lien just like a bank would take a mortgage, and you're foreclosing that lien against the property. When you do that, there will be issues of priority. So if there's a bank that already has a mortgage on the property, or there's other people who have liens, mechanics liens on the project that were recorded before you, they will have priority in line to get paid before you do. So priority is very important. Another reason to be prompt about getting your lien documents filed and served, because the order they're filed and served is the order of priority when you get paid. That's liens. Now let's talk about bonds. As I mentioned, generally you cannot lien a public project. Instead, bonds are used. In Minnesota, public projects in excess of $75,000 require 2 kinds of bonds. First, a performance bond and also a payment bond. These bonds are for the protection of both the government and of the subcontractors and material suppliers. General contractor is not protected by these bonds. You say, well, why is that? Well, the answer is because the assumption is if you are a general contractor doing a project for a government entity, because the requirements for municipalities and governments to pay a general contractor to do a project require the money to be there, you're not going to have a problem getting paid as a general. The performance bond protects the public. The performance bond says if the general contractor fails to get the work done for the municipality, then the bond company will have this bond, this pot of money, that will fund completion of the project if for some reason the general contractor cannot get the work done. A payment bond is what protects both, I guess, the government and the subs. The last thing that the government wants on a project is having subcontractors come through the woodwork or material suppliers come through the woodwork and say, hey, I haven't been paid. And so there's this payment bond, which of course is a pot of money from a bond company that says you can come get paid out of this bond if the general contractor for some reason has failed to pay the subs what they are owed. So that's how bonds work. Very different from liens. And again, they apply to public contracts. Now let's talk about how you can get paid through your contract rights. So you've struck out on your liens, something happened, you don't have any lien rights. It's not a public project, so there are no bonds. And you say to yourself, I'm out of luck. Not true. You can still sue for breach of contract. So if you have if you're the subcontractor and you have a contract with the general contractor, or you're a general contractor and you have a contract with the project owner and you haven't been paid, you can always assert a claim for breach of contract, which is as simple as, hey, I have this agreement with you. I said I'd do this work, you'd pay me $100 in return, you haven't paid me, I'm now suing you for breach of contract, you owe me $100. So there's still a lawsuit and you have a slightly different claim. You say to yourself, well, what's the difference? The difference is now you're suing for money damages. You're not suing as you would in a lien case for a right to the real estate so that you can sell it and take the proceeds of the sale. Here you're just saying, Your Honor, make them pay me $100. Has nothing to do with a lien, has nothing to do with their real estate. Just make them give me $100. The problem with this, the reason it's not as favorable to you is if they don't have the $100, it's an unsecured claim. Whereas if they don't have the $100, but you have a lien claim and the property has value, you can still sell their real estate and get your $100. So you lose some attractiveness on the contract right because it's an unsecured claim. The other thing you lose is a right to automatic attorney's fees. So if your contract has an attorney's fees provision, then you can potentially obtain attorney's fees in connection with a breach of contract claim. But the contract has to have an attorney's fees provision in order to do that. However, in the lien statute, if you are the contractor or the subcontractor asserting a lien and you win, you automatically have a right to get your fees, whether or not your contract with that person has a fees provision or not. You automatically have a right to get your fees if you're successful under the mechanics lien statute. So that's another important distinction. Okay, last thing to talk about today. You don't have lien rights because something went bad with the requirements. It's not a public project, so you don't have a bond. You didn't sign a contract, so you don't have a contract claim. Now you're saying to yourself, now I'm really hosed. Now I for sure can't get paid. There's still hope. The last thing that you can do if you get to a lawyer is have your lawyer help you assert some claim that is variously referred to in the law as unjust enrichment or promissory estoppel or quantum meruit. Those three claims are basically variation phrases on the same thing, which is we had a relationship. We may not have had a written agreement, but we had a relationship. You knew I was coming up to your property to do work for you. You consented to that happening. We may not have agreed on all the specifics, but I showed up and I did the work. And the value of my work to the improvement of your real estate is $100. Before I showed up, your property was worth $0. And after I left, your property was worth $100. You need to pay me for that, or you will be unjustly enriched, and the law just simply does not allow that kind of unfairness. So you go to the judge, you file a lawsuit, and you say, Judge, I don't have a lien, I don't have a bond, I don't even have a contract, but by gum, I showed up and I did work on this person's property, and they should have to pay me because the value of my work to them is $100. That's fair, that's just, please make them give me $100. Again, this is an unsecured claim. And again, you would not have the right to seek attorney's fees. So there's reasons why this is not as attractive as having a lien claim, but it is a backstop to get paid if you're up against the ropes and it's the last thing you have available to you. That's all I have today on getting paid with liens, bonds, and contracts. And I even added what you do when you don't have a contract as an extra bonus. So with that, Jesse, do we have any questions today for our last few minutes together?
First of all, thank you so much, Kyle. That was wonderful information. As for the question, I do not see any at this time. However, if anyone does think of a question, please feel free to reach out and we'll be sure to answer any questions for you. Are you able to go to the next slide for me?
I sure am.
All right, please take a moment to review us on Google. We would really appreciate that. All right, and with that, that is all we have for you today. Thank you again to Kyle, and thank you for everybody who attended. We hope to see you at our next webinar, and have a sunny day.
Thank you, everybody. Bye-bye.